My dear students, welcome back to our channel. Students, in this video I am explaining MBA first semester. Subject Legal and Business Environment. Important long questions and answers. Let's start quick revision. First unit. First important long question is: discuss the main features of Companies Act 2013. The Companies Act 2013 is a law in India that regulates how companies are formed, run, and closed. It aims to make companies more transparent, responsible, and accountable. Key features. 1. Incorporation of companies. It provides guidelines on how to register a company, including choosing a name, preparing documents, and getting approval from authorities. Example, a person can start a business, register it as a company and follow the rules of the Act. 2. Corporate governance. The Act sets out rules for the management and board of directors of a company. It requires companies to have at least 2 directors and to hold regular board meetings. Example, a company must have a board meeting to discuss important decisions like hiring or launching new products. 3. Financial disclosure. Companies must maintain proper financial records and submit annual reports like the balance sheet and profit and loss statements. Example, a company must publish its financial statements so that shareholders can see how well it is performing. 4. Protection of minority shareholders. The Act ensures that small investors, minority shareholders, are treated fairly and their interests are protected. Example, if a big shareholder is making decisions that harm small investors, the law allows these investors to voice their concerns. 5. Regulation of audit. The Act mandates companies to have their financial records audited by a qualified auditor. Example, a company's accounts are checked by an auditor to make sure everything is accurate and legal. 6. Corporate social responsibility, CSR. Large companies are required to spend a part of their profits on social causes like education and health. Example, a company may donate a portion of its earnings to build schools or support healthcare. Conclusion. The Companies Act 2013 helps to ensure that companies are run transparently, ethically, and legally. It provides a clear framework for company registration, management, financial reporting, and social responsibility, making businesses accountable to their stakeholders. It protects the rights of shareholders and promotes good governance, ensuring fair practices in the corporate world. Next important long question is: what is company? Explain steps and procedure for incorporation of the company. What is a company? A company is a legal entity formed by a group of people to conduct business. It can be small or large, and it can make profits. The company is separate from its owners, meaning it can own property, enter contracts, and be held responsible for its actions. Steps and procedure for incorporation of a company. 1. Choose a company name. Pick a unique name for the company that reflects the business. Example, a company selling shoes could be named Fast Foot Shoes Pvt Limited. 2. Apply for Digital Signature Certificate, DSC. The people who will sign the company's documents must have a digital signature. Example, the founders of the company will use DSC to sign electronic forms online. 3. Obtain Director Identification Number, DIN. Every director needs a unique identification number from the government. Example, if you want to be a director, you apply for a DIN which will help identify you legally. 4. Prepare the Memorandum and Articles of Association. Memorandum of Association, MOA, explains the company's purpose, name, and registered office. Articles of Association, AOA, outlines the rules for running the company. Example, if the company's aim is to sell products, the MOA would state that clearly. 5. Apply for name approval. You submit the company name to the government to get approval. Example, submit your company's name, and if it's available, the government will approve it. 6. File the incorporation documents. Submit forms like Form SPICE, INC 32, which includes the MOA, AOA, and details about the directors. Example, fill out online forms and submit them to the Ministry of Corporate Affairs, MCA. 7. Get certificate of incorporation. Once everything is approved, you receive a certificate of incorporation, making the company official. Example, after approval, the government issues a certificate stating the company is now a legal entity. Conclusion. Incorporating a company involves choosing a name, applying for digital signatures and identification numbers, creating key documents, and filing them with the government. Once approved, the company gets a certificate of incorporation, legally starting its business activities. This process ensures that the company is registered and follows all the rules and regulations. Next important long question is: discuss the procedure for appointing a director. Procedure for appointing a director. A director is a person appointed to manage and oversee the operations of a company. Here is the procedure for appointing a director in simple steps. 1. Check the company's Articles of Association, AOA. The company's rules, AOA, often state how directors should be appointed, including the number of directors and their qualifications. Example, if the AOA says the company needs at least 2 directors, the company must follow that rule. 2. Board of Directors decision. The current board of directors must meet and pass a resolution, a formal decision, to appoint a new director. Example, if the company needs more directors, the existing directors meet and vote to add someone. 3. Consent from the person to be appointed. The person being considered for appointment must give written consent to act as a director. Example, if a candidate named John is chosen, John must sign a consent form stating that he agrees to be a director. 4. Filing with the Ministry of Corporate Affairs, MCA. The company must file the director's details with the MCA within 30 days using the Form DIR 12. Example, after John's appointment, the company submits his details to the MCA to update the records. 5. Director Identification Number, DIN. The person being appointed must already have a director identification number, DIN, which is a unique number given to directors by the government. Example, if John does not already have a DIN, he must apply for it before his appointment is completed. 6. Board resolution. After obtaining consent, the board must pass a formal resolution to appoint the new director. Example, the board meets again and officially passes a resolution to appoint John as a director. 7. Intimation to the director. The company sends a formal letter to the newly appointed director confirming their appointment. Example, John receives an official letter from the company informing him of his appointment. Conclusion. Appointing a director involves several steps, reviewing the company's rules, getting the person's consent, submitting necessary forms, and ensuring the director has a DIN. The process ensures that the new director is legally recognized and officially part of the company's management. Next important long question is, what are the different powers and liabilities of directors under Companies Act? Powers of directors under the Companies Act. 1. Management of company affairs. Directors have the power to make decisions on behalf of the company, including managing day-to-day operations. Example, a director can decide on hiring employees, approving budgets, or entering into contracts for the company. 2. Board meetings and resolutions. Directors can call board meetings and pass resolutions to approve major decisions. Example, if the company wants to buy new machinery, the directors meet and approve the decision. 3. Delegation of powers. Directors can delegate certain powers to other officers or employees, like giving the authority to handle finances. Example, the director can delegate the responsibility of managing finances to the company's CFO. 4. Issue of shares. Directors can issue new shares, raising capital for the company as long as it aligns with the company's goals. Example, if the company needs more funds for expansion, the directors can issue new shares to raise money. 5. Borrowing power. Directors have the authority to borrow money on behalf of the company. Example, if the company needs a loan to build a new office, directors can sign loan agreements. Liabilities of directors under the Companies Act. 1. Fiduciary duty. Directors must act in the best interest of the company and its shareholders, putting the company's interest before their personal interests. Example, if a director has a personal business, they cannot make decisions that benefit their business over the company's interest. 2. Liability for fraud. Directors can be held personally liable for any fraudulent activity or misrepresentation made in the company's financial statements. Example, if a director falsely reports profits to attract investors, they can face legal consequences. 3. Non-compliance with laws. Directors can be held liable if the company violates laws, like failing to pay taxes or not filing necessary documents with authorities. Example, if the company misses filing tax returns, the directors can be fined. 4. Breach of duty. If a director breaches their duty or is negligent, they can be held liable for any losses caused to the company. Example, if a director makes an unsafe business decision that leads to a loss, they may be responsible. Conclusion. Directors hold significant powers to manage and make decisions for the company, such as managing operations, issuing shares, and borrowing money. However, they also have important responsibilities and can be held liable for actions like fraud, mismanagement, or violating laws. They must always act in the best interest of the company to avoid personal liability. Next important long question is, what do you mean by company meeting? How many kind of resolutions a company can pass in the meeting? Discuss. What is a company meeting? A company meeting is a formal gathering of the company's members, directors, or shareholders to discuss and make decisions on business matters. It is a crucial part of corporate governance, allowing stakeholders to vote on important issues. Types of resolutions a company can pass in a meeting. Resolutions are formal decisions made by the company in a meeting. There are three main types. 1. Ordinary resolution. This is the most common type of resolution passed during meetings. It requires a simple majority, more than 50% of votes in favor. Example, shareholders voting to approve the appointment of a new director or approving the financial statements. 2. Special resolution. This requires a higher majority, at least 75% of votes in favor. It is used for more significant decisions that can change the structure or operations of the company. Example, a special resolution is needed to alter the company's articles of association or to change the company's name. 3. Resolution by circulation. This is a decision made without holding a physical meeting. Directors or shareholders give their consent to a resolution in writing and the resolution is passed once the majority agrees. Example, if the board needs to approve a small decision quickly, such as a minor contract approval, they may pass a resolution by circulation. Conclusion. Company meetings allow shareholders, members, and directors to come together to make important decisions. The types of resolutions that can be passed are ordinary resolutions, simple majority, special resolutions, 75%, majority, and resolutions by circulation, written approval. These resolutions are essential tools for managing a company and ensuring that decisions align with its goals and legal requirements. Next important long question is, what is meant by winding up of a company and how many modes are there for winding up a company? Explain. What is winding up of a company? Winding up of a company refers to the process of closing down the business and settling its financial matters. It involves selling off the company's assets, paying off its debts, and distributing any remaining assets to shareholders. This process officially ends the company's existence. Modes of winding up a company. There are two main modes of winding up a company. 1. Voluntary winding up. This happens when the company's shareholders or members decide to close the company on their own, usually because the company no longer wants to continue its operations. Types of voluntary winding up. Members' voluntary winding up. This occurs when the company is solvent, meaning it can pay off all its debts. Shareholders agree to wind up the company voluntarily. Small black square example, a small business that has finished its work might choose to close itself and distribute remaining funds to the shareholders. Creditors' voluntary winding up. This happens when the company is insolvent, meaning it cannot pay its debts. Shareholders still decide to wind up the company, but creditors are involved in the process. Example, a company unable to pay back its loans decides to close down, and its creditors take part in the winding up process. 2. Compulsory winding up. This occurs when the court orders the company to close down, usually because of reasons like insolvency or illegal activities. A creditor, shareholder, or the government can apply to the court to force the company to wind up. Example, if a company refuses to pay its debts and a creditor takes the matter to court, the company might be ordered to wind up. Conclusion. Winding up is the formal process of closing a company, and it can happen in two ways, voluntary winding up, where shareholders decide to close the company, either solvent or insolvent, and compulsory winding up, which occurs when the court orders the closure. This process ensures that the company settles its debts and properly distributes remaining assets before it ceases to exist. Next, second unit. Second unit. First important long question is: define the term contract and explain the nature and elements of contract. What is a contract? A contract is a legally binding agreement between two or more parties to do or not do something in exchange for something else. It can be written or verbal, and it must be recognized by law. Nature of a contract. Mutual agreement. A contract involves an agreement between the parties where both have a common understanding. Legally enforceable. If either party breaks the agreement, the law can force them to fulfill their part or compensate the other party. Commitment. Once agreed, both parties are committed to fulfilling the terms of the contract. Elements of a contract. For a contract to be valid, it must have the following key elements. 1. Offer. One party must make an offer to do something or provide a service. Example: a seller offers to sell a car for a specific price. 2. Acceptance. The other party must agree to the offer made. Example: the buyer agrees to purchase the car at the price offered. 3. Intention to create legal relations. Both parties must intend to create a legal relationship, meaning they expect the agreement to be enforceable by law. Example: a business contract where both parties expect to be legally bound. 4. Consideration. There must be something of value exchanged between the parties, such as money, goods, or services. Example: the buyer gives money in exchange for the car. 5. Capacity to contract. Both parties must have the legal ability to enter into a contract. Example: they must be of legal age and sound mind. Example: a minor cannot sign a valid contract unless it's for essential items like food or education. 6. Free consent. Both parties must agree to the terms without any pressure, force, or fraud. Example: if someone is forced to sign a contract under threat, it is not valid. 7. Legality of the object. The subject matter of the contract must be legal. Example: a contract to sell illegal drugs is not valid. Conclusion. A contract is a formal agreement with legal consequences. For it to be valid, there must be an offer, acceptance, consideration, legal capacity, free consent, and the contract must involve legal actions. All these elements together ensure the contract is enforceable in a court of law. Next important long question is: explain breach of contract. What are the different remedies for breach of contract? What is breach of contract? A breach of contract occurs when one party fails to perform their obligations as stated in the contract. This could be a failure to do something they promised, doing something wrong, or not doing something at all. A breach can be partial or total, depending on the severity. Example: if a supplier agrees to deliver goods to a store by a certain date but fails to do so, this is a breach of contract. Different remedies for breach of contract. When a breach happens, the harmed party has legal options, remedies, to address the issue. Here are the common remedies. 1. Damages. Compensatory damages. These are the most common remedy. The Injured party is paid money to cover the loss caused by the breach. Example, if the store paid for goods that were never delivered, the supplier may have to pay the store for the cost of replacing the goods. 2. Specific performance. This is an order from the court directing the party who breached the contract to fulfill their promise. Example, if a person agrees to sell a unique painting and then refuses, the buyer can ask the court to force the seller to deliver the painting. 3. Injunction. This is a court order that prevents the breaching party from doing something or forces them to stop doing something. Example, if a company breaches a non-compete clause, a court might issue an injunction to stop them from working with a competitor. 4. Rescission. The contract is cancelled and both parties are released from their obligations. Example, if one party made a mistake or was tricked into signing a contract, they may ask for rescission to cancel the deal. 5. Reformation. If the contract was written incorrectly or does not reflect the true intention of the parties, the court can correct it. Example, if a contract had a mistake in terms like pricing, the court may correct it to reflect the original agreement. Conclusion. A breach of contract happens when one party doesn't fulfill their obligations. The harmed party can seek remedies like damages, money, specific performance, forcing the other party to complete the contract, injunctions, court orders to stop actions, rescission, cancelling the contract, or reformation, correcting the contract. These remedies ensure that the harmed party is compensated or the contract is enforced as agreed. Next important long question is: explain about essential elements of offer and acceptance. Essential elements of offer and acceptance. Offer and acceptance are the foundation of any contract. Both parties must agree to the terms of the contract for it to be valid. Here's a breakdown of the essential elements. 1. Offer. An offer is a proposal made by one party to another, showing their willingness to enter into a contract under specific terms. To be valid, the offer must have the following elements. Clear and specific terms. The offer must be clear, definite, and not vague. Example, I will sell my car to you for 500,000 rupees is a clear offer. Intention to create legal relations. The offer must show an intention to form a legally binding agreement. Example, a business offering goods for sale clearly intends to create a contract. Communication. The offer must be communicated to the other party to be valid. Example, if one person offers to sell a phone to another, they must tell the other person about it. Capability of acceptance. The offer must be made to someone who can accept it. Example, you can't offer to sell a product to someone who is not legally capable of entering a contract, like a minor. 2. Acceptance. Acceptance is the agreement of the person receiving the offer to the terms set out. The essential elements of acceptance are: unconditional. Acceptance must be clear and unequivocal. It must agree to all the terms of the offer without changes. Example, if someone offers to sell a car for 500,000 rupees and the buyer agrees to that price, this is an acceptance. Communication of acceptance. The acceptance must be communicated back to the offerer. Example, a buyer says, I accept your offer to buy the car. This statement is the communication of acceptance. Timeliness. acceptance must occur within a reasonable time or as specified in the offer. Example, if the offer to buy a product is valid for 3 days, the acceptance must happen within that period. Conclusion. For a valid contract, there must be a clear offer with definite terms and an unconditional acceptance of those terms. Both the offer and acceptance must be communicated, and acceptance must be timely. Once both elements are satisfied, a contract is formed. Next important long question is: distinguish between a condition and warranty. Difference between condition and warranty. In the context of a contract, especially in the sale of goods, conditions and warranties are important terms that define the rights and duties of the parties involved. Here's the distinction. 1. Condition. A condition is a fundamental term of the contract. If it is breached, the affected party can terminate the contract and claim damages. Example, if a car dealership promises to deliver a car with a working engine and the engine is faulty, this is a breach of condition. The buyer can cancel the contract and demand a refund or replacement. Key features of condition. Vital to the contract. Breach allows the innocent party to terminate the contract and seek compensation. Example, in a contract, a condition that goods must be delivered within a specified time. 2. Warranty. A warranty is a secondary term. It is less important than a condition. If it is breached, the affected party cannot terminate the contract but may seek damages for the loss suffered. Example, if a car dealership promises that the car's paint will remain unchipped for a year, but it gets chipped after 6 months, the buyer can't cancel the contract but can claim damages for the cost of repainting. Key features of warranty. Not crucial to the main purpose of the contract. Breach results in a claim for damages but does not allow termination of the contract. Example, in a contract, a warranty stating the product has a 1-year guarantee against defects. Key differences. Condition. Fundamental term of the contract. Breach allows termination of the contract. Breach has a major effect on the contract's purpose. Warranty. Less important term of the contract. Breach does not allow termination, only damages. Breach does not seriously affect the contract's core purpose. Conclusion. A condition is a critical part of a contract, and its breach allows the contract to be terminated. A warranty, on the other hand, is a less important term and a breach results in damages, but the contract remains valid. Understanding these differences helps in knowing what actions to take in case of a breach. Next important long question is: explain the objectives and essential elements of Sale of Goods Act 1930. Objectives of the Sale of Goods Act 1930. The Sale of Goods Act 1930 governs the sale and purchase of goods in India. The key objectives of the Act are: 1. Regulation of transactions. The Act regulates the sale of goods to ensure fairness in contracts between buyers and sellers. Example, it helps buyers know their rights if the goods they purchase are defective. 2. Protection of buyer and seller rights. The Act defines the rights and duties of both buyers and sellers. Example, if a buyer purchases goods that do not meet the promised quality, they can seek a remedy under the Act. 3. Clear terms for contracts. The Act helps make the terms of sale clear. for both parties, reducing the possibility of disputes. Example, it clearly defines what constitutes a valid sale contract and what remedies are available in case of breach. Essential elements of the Sale of Goods Act 1930. For a contract to be a valid sale of goods, the following elements must be present. 1. Contract of sale. A contract where ownership of goods is transferred from the seller to the buyer for a price. Example, a person buys a mobile phone from a shop and ownership passes from the seller to the buyer once the price is paid. 2. Goods. The subject matter of the sale must be goods, meaning movable items that can be bought and sold. Example, a contract for the sale of a laptop, car, or furniture is valid under the Act as these are movable goods. 3. Price. There must be a price agreed upon by both parties for the sale of goods. Example, if a person agrees to buy a bicycle for 10,000 rupees, that 10,000 rupees is the agreed price. 4. Transfer of ownership. The ownership of the goods must pass from the seller to the buyer. Example, once the buyer pays for a book in a store, the ownership of the book passes to them. 5. Offer and acceptance. There must be an offer by the seller and an acceptance by the buyer. Example, a seller offers to sell a sofa, and the buyer accepts the offer by agreeing to the terms and paying the price. 6. Capacity to contract. Both the buyer and seller must have the legal ability to enter into a contract. Example, they must be of sound mind and of legal age. Example, a minor cannot legally buy goods under this Act unless it's for essential needs. Conclusion. The Sale of Goods Act 1930 governs the sale and purchase of goods, aiming to protect the rights of both buyers and sellers. Essential elements include the transfer of ownership, a price, goods as the subject matter, and an offer and acceptance. By defining these rules, the Act ensures fair trade and dispute resolution. Next, third unit. Third unit. First important long question is: discuss about the Negotiable Instruments Act 1881. Negotiable Instruments Act 1881. The Negotiable Instruments Act 1881 is a law in India that governs negotiable instruments like promissory notes, bills of exchange, and checks. These are financial documents that can be transferred from one person to another, allowing the holder to claim payment. The Act provides the legal framework for their usage, transfer, and enforcement. Key features of the Negotiable Instruments Act. 1. Definition of negotiable instruments. A negotiable instrument is a document that guarantees the payment of a specific amount of money either on demand or at a set time. Examples: a check, payable to a specific person, a promissory note, a promise to pay, or a bill of exchange, a written order to pay. 2. Transferability. Negotiable instruments can be transferred from one person to another, allowing the holder to claim the payment. Example: if A writes a check to B, and B transfers the check to C, C can legally present the check to the bank for payment. 3. Holder in due course. A person who receives a negotiable instrument in good faith, without knowledge of any defects, and for value, is known as a holder in due course. Example: if C buys a dishonored check from B without knowing its dishonor, C is considered a holder in due course and has the right to claim the payment from the drawer. 4. Presumptions. The Act assumes that certain conditions are automatically met when dealing with negotiable instruments unless proven otherwise. Example, if a check is presented for payment, it is presumed to be issued for payment unless the issuer proves otherwise. 5. Liability of parties. The parties involved in a negotiable instrument, drawer, drawee, payee, have specific liabilities and responsibilities if the instrument is dishonored or not paid. Example, if a check is dishonored due to insufficient funds, the drawer, the person who wrote the check, is responsible for the payment. Conclusion. The Negotiable Instruments Act, 1881 provides a clear legal framework for using financial instruments like checks, promissory notes, and bills of exchange. It ensures that these instruments can be transferred between parties, allows the holder to claim payment, and protects the rights of holders in due course. The Act is essential in regulating and ensuring the smooth operation of financial transactions. Next important long question is: explain difference between promissory note and check under the Negotiable Instruments Act. Difference between promissory note and check. Both promissory notes and checks are negotiable instruments under the Negotiable Instruments Act, 1881, but they have different characteristics. Here's a simple comparison. 1. Definition. Promissory note, it is a written promise by one party to pay a specific amount of money to another party, either on demand or at a fixed or determinable future time. Example, a person writes, I promise to pay 10,000 rupee to X on or before 30th June. Check. A check is a written order from the drawer, the person who writes the check, to a bank to pay a specific amount of money to the payee, the person receiving the money. Example, a person writes a check to pay 5,000 rupee to X, directing the bank to transfer this amount. 2. Parties involved. Promissory note involves two parties, the maker, the person promising to pay, and the payee, the person receiving the payment. Example, A writes a promissory note to be promising to pay 5,000 rupees. Check involves three parties, the drawer, the person writing the check, the drawee, the bank that is directed to pay, and the payee, the person receiving the money. Example, A writes a check to be directing the bank, drawee, to pay 5,000 rupee to be payee. 3. Payment time. Promissory note, the payment can be made either on demand or at a specific time in the future. Example, a promises to pay be 10,000 rupees on 1st July. Check, it is payable on demand, the payee can cash or deposit the check immediately when presented to the bank. Example, A writes a check to B, and B can deposit it into their bank account right away. 4. Bank involvement. Promissory note, no bank is involved in the transaction. The payment is made directly from the maker to the payee. Example, a pays be 10,000 rupees in cash based on a promissory note. Check, a bank is always involved, as the check is drawn on the drawer's bank to make the payment. Example, A gives B a check, which B presents to A's bank to receive the amount. 5. Transferability. Promissory note can be transferred, but the transfer process is generally more complex than a check. Example, A can transfer a promissory note to C, who can then claim payment from A. Check is easily transferable and can be passed to others as payment through endorsement and delivery. Example, A gives B a check, and B can endorse it to C, who can deposit it. Conclusion. A promissory note is a promise to pay a debt, while a check is an order to a bank to pay money. A check is payable on demand, involves the bank, and is transferable easily, while a promissory note can be payable later and does not involve a bank in the payment process. Next important long question is: define bills of exchange. What are the different types of bills of exchange under the Negotiable Instruments Act? What is a bill of exchange? A bill of exchange is a written document in which one party, the drawer, orders another party, the drawee, to pay a specified amount of money to a third party, the payee, at a future date or on demand. It is used in trade transactions to ensure payment for goods or services. Example: a seller, A, gives a bill of exchange to the buyer, B, instructing B to pay 10,000 rupee to C, the seller's creditor, on the 30th of next month. The bill serves as a guarantee of payment. Types of bills of exchange under the Negotiable Instruments Act. 1. Sight bill, payable on demand. A bill of exchange that is payable immediately when presented for payment. Example: if a buyer agrees to pay for goods right after receiving the bill of exchange, it is a sight bill. 2. Time bill, payable after a certain time. A bill of exchange that is payable after a certain period, usually a specific number of days or months after it is accepted. Example: a seller issues a bill stating that 5,000 rupees should be paid 30 days after the acceptance of the bill. 3. Foreign bill. A bill of exchange drawn in one country, but payable in another country. Example: a company in India issues a bill to be paid in the United States for goods sold to a foreign customer. 4. Inland bill. A bill of exchange that is drawn and payable within the same country. Example: a bill issued by a seller in Mumbai to a buyer in Delhi is an inland bill. 5. Trade bill. A bill of exchange used in business transactions for the sale of goods. Example: a manufacturer sends a bill to a wholesaler for the sale of raw materials. 6. Accommodation bill. A bill drawn for the purpose of providing financial assistance to one party without any goods or services exchanged. It is often used as a form of short-term loan. Example: a person may sign a bill of exchange to help a friend obtain a loan even though no goods were sold. Conclusion. A bill of exchange is an essential financial instrument in trade, directing one party to pay a sum of money to another. There are various types, including sight bills, time bills, foreign bills, and inland bills, each serving different purposes based on the timing and location of payment. These types ensure smooth financial transactions, especially in commercial and international trade. Next important long question is: explain in detail about RBI guidelines towards digital transactions. RBI guidelines on digital transactions. The Reserve Bank of India, RBI, has issued several guidelines to ensure the safety, security, and efficiency of digital transactions. These guidelines aim to protect consumers, encourage adoption of digital banking, and maintain the stability of the financial system. Key guidelines on digital transactions. 1. Customer protection and privacy. RBI mandates that banks must protect the privacy of customers during digital transactions. This means personal data and transaction details must be encrypted and stored securely. Example, if you make an online payment or transfer money, your banking details and personal information should be encrypted to prevent unauthorized access. 2. Secure payment systems. The RBI has made it mandatory for banks and financial institutions to ensure that their payment systems are secure. This includes using methods like two-factor authentication, 2FA tokenization, and SSL encryption for online transactions. Example, when you make an online payment, you may receive a one-time password, OTP, as part of the authentication process. This helps ensure the transaction is legitimate. 3. RBI's Digital Payment System, NPS, Guidelines. The RBI has set up guidelines to ensure interoperability among various digital payment platforms like UPI, Unified Payments Interface, IMPS, Immediate Payment Service, and RTGS. Real-time gross settlement, ensuring users can easily transfer money across different platforms. Example, you can use your bank's mobile app to send money to someone using a different bank or app because of the interoperability rules set by RBI. 4. Regulation of Prepaid Payment Instruments, PPIs. RBI has issued rules on the issuance and usage of prepaid payment instruments, PPIs, such as digital wallets, example, Paytm, PhonePe. These rules ensure that PPIs are safe, their balances are protected, and they are used for legitimate transactions. Example, when you load money into your Paytm wallet, the amount is protected under RBI guidelines to ensure it is not misused. 5. Transaction limits. RBI sets certain limits on digital transactions, particularly for payment instruments like mobile wallets or UPI transactions to reduce risks like fraud and financial instability. Example, there might be a daily limit on the amount you can transfer or pay via UPI to prevent unauthorized or excessive transactions. 6. Fraud prevention and redress mechanism. RBI encourages the setting up of fraud detection systems and clear redressal mechanisms. If a customer faces any issues like unauthorized transactions, the bank is required to resolve the issue within a set time frame. Example, if you report an unauthorized debit from your account, the bank must investigate and refund the amount if the fraud is proven. Conclusion. The RBI's guidelines on digital transactions aim to enhance the security, efficiency, and trust in digital banking. These guidelines protect consumer data, ensure secure payment systems, regulate digital wallets, and provide mechanisms for fraud detection and redress. As digital payments grow in India, these measures ensure safer and smoother transactions for users. Next, fourth unit. Fourth unit. First important long question is: write a note on New Industrial Policy of India, 1991, and what are the latest developments. New Industrial Policy of India, 1991. The New Industrial Policy of 1991 was a landmark economic reform introduced by the Indian government to liberalize the Indian economy and promote industrial growth. The policy aimed to shift from a controlled and regulated economy to a more market-driven one, opening up opportunities for private businesses and foreign investments. It was a response to the economic crisis India faced during the early 1990s, including a balance of payments crisis, and a slowdown in industrial growth. Key features of the 1991 Industrial Policy. 1. Liberalization. The policy reduced government control over industries. The industrial licensing system was relaxed, meaning businesses no longer required permission from the government to start or expand their operations. Example, before 1991, businesses needed approval from the government to expand, but after the policy, they could do so freely. 2. Foreign investment and technology. The policy encouraged foreign direct investment, FDI, and allowed foreign companies to enter the Indian market. Example, foreign companies like Ford, General Motors, and Coca-Cola were able to invest in India, which boosted the economy. 3. Privatization. The government reduced its involvement in the public sector and encouraged the privatization of state-owned enterprises. This was aimed at improving efficiency and productivity. Example, companies like Indian Airlines and Air India faced increased competition from private companies due to this policy shift. 4. Deregulation. The policy removed restrictions on industries, such as the monopolies and restrictive trade practices. Example, businesses were allowed to set their own prices, leading to greater competition and consumer choice. 5. Focus on exports. The policy emphasized the importance of export-oriented industries to integrate India into the global economy. Example, export promotion schemes were introduced for industries like textiles, which allowed them to compete in the global market. Latest developments. In recent years, the Indian government has continued to build on the foundation laid by the 1991 policy. Key developments include: Conclusion. The new industrial policy of 1991 set the stage for India's economic liberalization and growth, opening up the economy to private and foreign investments. The latest developments, such as Make in India and Atmanirbhar Bharat, continue to build on this foundation, aiming to strengthen India's position as a global manufacturing hub and increase self-reliance. Next important long question is: explain the recent banking sector reforms in India. Recent banking sector reforms in India. In recent years, India has implemented several banking sector reforms to strengthen the financial system, improve efficiency, and increase access to banking services for the public. These reforms aim to boost economic growth, ensure financial stability, and promote digitalization in banking. Key reforms. 1. Pradhan Mantri Jan Dhan Yojana, PMJDY. Launched in 2014, this scheme aimed to provide universal access to banking by opening bank accounts for all citizens, especially those in rural areas. Example, millions of people, especially from rural and low-income backgrounds, were able to open basic bank accounts, providing them with access to banking services like savings, insurance, and direct benefit transfers. 2. Banking Regulation, Amendment, Act, 2020. The RBI was given more powers to supervise and regulate private sector banks, including the ability to conduct mergers and ensure smooth functioning. Example, this law ensures that even private sector banks are subject to strict regulatory oversight, preventing financial instability. 3. Insolvency and Bankruptcy Code, IBC, 2016. This law helps to resolve cases of non-performing assets, NPAs, in the banking sector by providing a legal process to recover loans and restructure debts. Example, if a company fails to repay loans, the IBC allows the banks to take legal action and recover the debt efficiently, reducing the risk of bad loans. 4. Digital banking and payments. The government and the RBI have pushed for increased digital banking and cashless transactions through initiatives like UPI, Unified Payments Interface, which allows easy money transfers using smartphones. Example, UPI apps like Google Pay, PhonePe, and Paytm have gained immense popularity, offering users an easy and quick way to transfer money. 5. Recapitalization of public sector banks, PSBs. The government has injected capital into public sector banks to help them cope with bad loans and improve their financial health. Example, banks like State Bank of India, SBI, and Punjab National Bank, PNB, have received funds to strengthen their balance sheets and support lending. 6. Encouraging financial inclusion. There have been efforts to bring more people into the formal banking system through financial literacy programs, microfinance initiatives, and small loans. Example, the Mudra scheme provides loans to small businesses and entrepreneurs to boost entrepreneurship in rural areas. Conclusion. The recent banking sector reforms in India have focused on improving financial inclusion, promoting digital payments, strengthening regulatory frameworks, and addressing the issue of bad loans. These efforts aim to build a more inclusive, efficient, and resilient banking system that can contribute to India's economic growth and stability. Next important long question is: explain the responsibilities and functions of Niti Aayog. Responsibilities and functions of Niti Aayog. Niti Aayog, National Institution for Transforming India, was established in 2015 by the Indian government to replace the Planning Commission. Its purpose is to foster cooperative federalism, promote sustainable development, and guide India's economic policy. Niti Aayog works closely with both the central and state governments to shape policies that contribute to India's growth. Key responsibilities. 1. Policy formulation and guidance. Niti Aayog provides policy recommendations and suggestions to the government on various developmental issues like poverty alleviation, economic growth, infrastructure, and social development. Example, Niti Aayog played a crucial role in formulating the National Strategy for Artificial Intelligence, aiming to make India a leader in AI innovation. 2. Promoting sustainable development. The institution emphasizes sustainable development and ensuring that economic growth does not harm the environment. It encourages initiatives that balance growth with ecological preservation. Example, it is involved in initiatives like National Action Plan on Climate Change to help India reduce its carbon footprint. 3. Cooperative federalism. Niti Aayog works with state governments to align national and state policies. It ensures that development is inclusive, taking into account regional disparities. Example, through its SDG India Index, Niti Aayog assesses the progress of states in achieving the Sustainable Development Goals. SDGs, fostering a competitive environment among states. 4. Monitor and evaluate government programs. Niti Aayog monitors the performance of major government schemes and initiatives, making recommendations for improvements. Example, it evaluates programs like Swachh Bharat Abhiyan to ensure effective implementation and identify areas for improvement. 5. Fostering innovation and research. Niti Aayog supports innovation through its initiatives, including the Atal Innovation Mission, AIM, which encourages young innovators and entrepreneurs to create new solutions. Example, the Atal Tinkering Labs promote innovation among school students and help develop solutions for social problems. Conclusion. Niti Aayog plays a vital role in shaping India's development by offering policy advice, promoting sustainability, fostering innovation, and ensuring coordinated action between central and state governments. Its work has contributed to India's transformation by supporting efficient, inclusive, and innovative growth. Strategies. Next, fifth unit. Fifth unit. First important long question is Consumer Protection Act 2019. Consumer Protection Act 2019. The Consumer Protection Act 2019 was enacted to protect the rights of consumers in India, ensure fair trade practices, and resolve consumer disputes effectively. It replaced the earlier Consumer Protection Act, 1986, with more modern provisions to address the challenges of a growing economy and the rise of e-commerce. Key features of the Consumer Protection Act 2019. 1. Consumer rights. The Act guarantees basic rights to consumers, such as right to safety, protection against products or services that could harm the consumer, right to information, right to know the details about the goods or services they are purchasing, right to choose. Consumers can select from a variety of products or services at competitive prices. A right to redress, right to get a solution, compensation, replacement or repair if goods or services are faulty. Example, if you buy a faulty smartphone, you have the right to get a replacement or repair under the Act. 2. Central Consumer Protection Authority, CCPA. The Act establishes a Central Consumer Protection Authority, CCPA, which can take action against unfair trade practices like misleading advertisements, counterfeit products, and more. Example, CCPA can take action against companies making false claims about health products or medicines. 3. E-commerce regulations. The Act also addresses issues arising in the e-commerce sector, ensuring that online businesses follow fair trade practices, give proper refunds, and clearly mention return policies. Example, if you buy a product online and it is damaged or not as described, the platform must offer a refund or replacement as per the new rules. 4. Consumer Disputes Redressal Commissions. The Act sets up a three-tier system of consumer disputes redressal commissions at the district, state, and national levels to resolve complaints. The system is designed to be faster and more accessible. Example, if a customer is dissatisfied with a product and cannot resolve the issue with the seller, they can file a complaint at the Consumer Forum. 5. Product liability. The Act introduces the concept of product liability, holding manufacturers and service providers accountable for defective products or services. Example, if a defective appliance causes harm, the manufacturer or seller can be held responsible. Conclusion. The Consumer Protection Act 2019 empowers consumers by providing stronger rights, quicker dispute resolution mechanisms, and greater protection against unfair trade practices. It has modernized consumer laws to meet the needs of the digital age and offers better tools for addressing complaints, ensuring fairness in the marketplace. Next important long question is: write about intellectual property rights. Intellectual property rights, IPR, are legal protections granted to individuals or organizations for their creations or inventions. These rights are meant to encourage innovation by giving creators exclusive control over their work for a certain period. IPRs can apply to inventions, designs, artworks, brands, and more. Key types of intellectual property rights. 1. Copyright. Copyright protects original works of authorship such as books, music, movies, software, and art. The creator has the exclusive right to reproduce, distribute, or perform the work. Example: if a writer publishes a novel, they have the copyright to that book, preventing others from copying it without permission. 2. Patents. A patent is granted for new inventions or processes that offer a new way of doing something. It gives the inventor exclusive rights to make, use, or sell the invention for a specific time, usually 20 years. Example: if an inventor creates a new type of engine, they can patent it to prevent others from using the same technology without permission. 3. Trademarks. Trademarks protect brand names, logos, slogans, or symbols used to identify products or services. They help customers recognize the brand. Example: the Nike swoosh logo or the word Coca-Cola is trademarked, meaning no one else can use these marks for their products. 4. Design rights. These protect the visual appearance or design of products. It covers shapes, patterns, and colors that give a product its unique look. Example: the unique design of a Coca-Cola bottle is protected under design rights. 5. Trade secrets. Trade secrets protect confidential business information such as recipes, formulas, or business strategies. These rights don't require registration. Example: the formula for Coca-Cola is a trade secret that the company keeps confidential to prevent competitors from copying it. Conclusion: intellectual property rights are vital for protecting the creations and inventions of individuals and businesses. They ensure that creators have control over their work and can benefit financially from their ideas. IPRs encourage innovation, support the economy, and provide legal remedies against unauthorized use of creative works. Next important long question is: explain different features of environmental law, particularly under water and air pollution. Features of environmental law focus on water and air pollution. Environmental law aims to protect the environment, prevent pollution, and ensure the sustainable use of natural resources. In India, laws related to water and air pollution are particularly important as they help manage and reduce environmental harm caused by industrial activities, urbanization, and other human actions. Key features of environmental laws related to water pollution. 1. Water, Prevention and Control of Pollution, Act, 1974. This act aims to prevent and control water pollution. It establishes the Central Pollution Control Board, CPCB, and State Pollution Control Boards, SPCBs, to monitor and regulate water quality. Example: industries are required to treat wastewater before discharging it into rivers or lakes to prevent contamination. 2. Regulation of industrial effluents. The law requires industries to treat effluents, wastewater, before releasing them into water bodies. This prevents harmful chemicals and toxins from polluting drinking water and aquatic ecosystems. Example, a textile factory must treat the chemicals used in dyeing before discharging the water into nearby rivers. 3. Water quality standards. The Act sets standards for acceptable water quality for both drinking and industrial use. Any discharge above the permissible limit can lead to penalties. Example, if a chemical plant discharges water with harmful levels of mercury into a river, it will be fined for violating water quality standards. Key features of environmental laws related to air pollution. 1. Air, Prevention and Control of Pollution, Act, 1981. This act focuses on reducing air pollution. It empowers the CPCB and SPCBs to set standards for air quality and regulate emissions from industries and vehicles. Example, a coal-powered plant is required to limit the emissions of smoke and particulate matter to prevent air pollution. 2. Emission standards for industries. The law specifies permissible limits for pollutants such as sulfur dioxide, nitrogen oxides, and particulate matter in the air. Example, a steel factory must install filters to reduce smoke and pollutants that can harm air quality. 3. Pollution control and penalties. If an individual or organization violates air quality standards, they may face heavy fines or be ordered to shut down operations until they comply with regulations. Example, a transport company using vehicles that emit excessive smoke may be fined or forced to upgrade its fleet to meet pollution control standards. Conclusion. Environmental laws play a crucial role in controlling water and air pollution. Through regulations like the Water, Prevention and Control of Pollution Act and the Air, Prevention and Control of Pollution Act, India seeks to maintain clean water bodies and reduce harmful emissions into the air. These laws hold industries accountable, ensure sustainable practices, and protect public health, contributing to a cleaner and safer environment. Next important long question is Green Tribunal in Protecting Environment. Green Tribunal in Protecting the Environment. The National Green Tribunal, NGT, was established in India under the National Green Tribunal Act, 2010, to handle environmental disputes and protect the environment. It is a specialized body that deals with cases related to environmental laws, pollution, and natural resource management. Key features and functions of NGT. 1. Dispute resolution. The NGT provides a platform for resolving disputes related to environmental issues. It ensures that the cases are settled quickly, without going through the lengthy judicial process. Example, if a factory causes air or water pollution, affected citizens or environmental organizations can approach the NGT to seek remedies. 2. Environment protection. NGT focuses on protecting natural resources like rivers, forests, and wildlife. It ensures that projects and activities adhere to environmental laws and regulations. Example, if a construction project threatens a forest area, the NGT can stop the project or demand mitigation measures to protect the environment. 3. Power to impose penalties. The tribunal has the authority to impose penalties on industries or individuals violating environmental laws. This includes orders for compensation or compensation for environmental damage. Example, if a company pollutes a river, the NGT can fine them and direct them to clean up the pollution and compensate affected communities. 4. Specialized jurisdiction. NGT has experts in environmental law, science, and policy, making it capable of making informed decisions on complex environmental issues. This ensures that justice is served efficiently. Example, when a large industrial project affects the local biodiversity, the NGT can analyze its environmental impact through expert reports before making a decision. 5. Public participation. The tribunal encourages public participation in environmental protection. Citizens, environmental groups, and other stakeholders can approach NGT with complaints or concerns about environmental issues. Example, a group of citizens can file a case against a polluting factory in their area, and the NGT will consider their concerns while making a decision. Conclusion. The National Green Tribunal, NGT, plays a vital role in protecting the environment in India. It provides quick and effective dispute resolution, ensures compliance with environmental laws, and imposes penalties on violators. By focusing on specialized environmental issues, the NGT contributes significantly to maintaining India's natural resources and promoting sustainability for future generations.